Okay, so last class we talked about intentional torts. Today we're going to talk about unintentional torts.
Are you recording?
Stop recording.
I did. Unintentional torts are when a person acts in a careless fashion that results in an injury to another person, their property, or both. And there are two categories of unintentional torts. So we talked about intentional and unintentional. So they're the two broad categories. And then under the intentional, we talked about all those different types of intentional torts last class. The torts against the person, the torts against the property. Today, we're going to talk about the unintentional types of torts. And there are two broad categories under unintentional torts. The first one is negligence. And the second is strict liability. I'm going to explain what these are first, and then I'm going to go in and explain them in detail and talk about the elements associated with them. So first, negligence is when there's an injury that's caused by someone's carelessness, some act that they performed in a careless fashion. The key here with negligence is that it's unintentional. We don't intend per se the consequences of our actions. This is what we think of when we think of an accident. It's accidental, and it results from the failure to exercise the degree of care that a reasonable person would have exercised in the same circumstances. This is the most common type of tort that we can think of today. The second is strict liability, and this is a doctrine that states that some activities are so dangerous that liability will always follow an injury resulting from this type of action. Okay, and if people are engaged in ultra-hazardous activities and an accident occurs, they are liable regardless of how careful they were or regardless of intent. So again, no intent is required here. They're liable, they're responsible for the outcome regardless of how careful they were. Yes?
You say liable, do you mean they're liable for themselves or they're liable for
The damage to another person. They're also liable to their own damages if that happens. But they're liable to somebody else. So remember, when we're dealing with torts, we're dealing with the infringements of rights, the damage to somebody else. So somebody can sue you for strict liability if you damage them or their property as a result of some activity that you engage in that's considered to be ultra-hazardous. Okay, go ahead.
Could you give like an example of one of these activities?
I will, yeah.
I was gonna say, is that like if you go like skydiving, you have to like do like liability that goes with it?
Okay. So when you're dealing with like ultra-hazardous activities that you personally engage in and you take on the risk associated with that, that's not per se it's an ultra-hazardous activity, but you're assuming the risk for yourself. When you're dealing with a strict liability tort, it's you're harming somebody else. Follow me? It's your harm that you cause to somebody else, not per se to you. Okay, Reva.
How do they determine what's ultra hazardous, like you call it strictly harmful?
Yeah, that's what Alex is trying to get at. So there are certain activities like having wild animals as pets, playing with using explosives, things that are, really just considered to be ultra hazardous. Those would.
Wouldn't any crime be considered?
No, we're not dealing with crimes here. We're dealing with activities that people might engage in.
No, but can't you argue that anything is crime?
No.
That has a...
No. No. You can't necessarily argue that anything walking down the street is not ultra hazardous. You know, playing with explosives, potentially playing with guns. Those could be ultra hazardous activities. Okay, let's focus on negligence first. There are 4 elements that are required to be able to prove a case of negligence. All 4 of these elements must be present to prove a case of negligence. So if I were suing somebody for negligence, I have to prove that all 4 of these elements existed before I could win my case for negligence. So there has to be a duty of care. There has to be a breach of that duty. The action must be the proximate cause, and there must be an actual injury. And I'm going to go through each of these. I'll give you a couple of examples. So I'm a runner. I jog, okay? I often jog on the street. I would say that most of the time, I jog in a reasonable fashion. I actually don't wear anything on my ears or anything, or listen to music or anything, because when I am jogging on the street, I want to make sure if I hear of a car is coming up behind me or anything, is coming up behind me. What's that, Albert? I do jog facing into traffic, yeah. But then they because the roads are tilted, they say you get repetitive stress injuries from, doing things. And so because the road is tilted, and if you're jogging facing traffic, then you're always jogging with one side down. So in some neighborhoods, I'll jog on the opposite side, so I don't have that problem.
I feel like it'd be really boring to drive down.
Say what?
I feel like really boring.
Boring to jog? No, it's a good way to think. It's a good way to think. Anyway, so when I'm jogging, would you guys agree that any cars that are sharing the road with me have an obligation to keep me safe? They should not be trying to hit me, correct? Right? Okay. Okay. So we would argue then that drivers would have a duty of care, okay, to any pedestrians or people jogging on the street and whatnot. They have a duty to care. Now, if somebody hit me, would that be a breach of that duty? If they hit me, I'm just jogging my normal route, I'm on the right side facing traffic or something. If they hit me, that's a breach of their duty. They're not caring. They're not paying attention enough to avoid me. And if I fly over onto somebody's lawn and break my arm, would their hitting me have been the cause of that injury? Okay. And is it foreseeable that if they hit me with their car, that I would get injured? Is it foreseeable?
Yes.
You've lost that privilege. You too. Okay, so I've never had to take his away from him before. That's his warning. So the hitting of me is the proximate cause of my injury. And did I actually break my arm? Yes. So there's actual harm. So all 4 elements are present. Okay? And so therefore, I would probably win a lawsuit against the driver of the car as it relates to negligence. Okay? So let's look at some more legal definitions of these 4 elements. Duty of care. All of us have a duty to not violate the rights of others. And in a case where there's a civil lawsuit by one party against the other, the plaintiff has to demonstrate that the defendant owed him a duty of care. Okay, I'm going to use another case. Let's say we have a public swimming pool. And at that public swimming pool, there's a diving board. Okay? And public swimming pools, they get inspected. They get inspected by the local town that they're in. They're going to get inspected by the state. Maybe there's other parties that have to inspect them for various different reasons. But the authorities that inspect them have different responsibilities. So like the state might have an overall responsibility as to safety. The town might have an overall responsibility as to safety. The town might have an additional burden as to safety of the water, for instance, or safety relating to the cement surrounding the pool or the diving board, etc. Okay? So let's see who has a duty of care in this particular case. So while using a diving board at a local pool, Julia was injured. The injury could have been avoided if the diving board had a guardrail. Julia sued her state's Department of Health, arguing that the department had inspected the pool but did not do anything about the missing guardrail. So, on the surface, does it seem like there's a duty of care? Right? Okay, so it would seem like there is. However, let's look. In the Department of Health's area of authority, the area of authority that they had control over was actually the water that was in the pool. So therefore, when Julia sued the State Department of Health as it relates to her injuries from the diving board because of the guardrails not being there, she lost her lawsuit. She didn't win this suit because the State Department of Health didn't have a duty of care. They were responsible for the safety of the water. They weren't responsible for the safety of the equipment surrounding the pool. Okay? So she really, essentially, she sued the wrong party. Okay? So in all likelihood, if she'd sued the town, she would have won her suit against the town. They were responsible for other elements of the safety of the pool.
Can I say
Okay.
that now?
She can. She certainly can. She can turn around and sue, right, the town, okay? But that's part of her due diligence that she has to do prior to starting in a lawsuit. You need to know who are the parties that you should sue, who's responsible for what. She has to do some research. All right. Breach of duty. The breach of duty is the failure to use the degree of care that a reasonable person would exercise in that same situation. And what we use here is the reasonable person standard. What would the average person do in that situation? So, again, I'll give you another example. There's a walkway in front of your home. It has some cracks in it that could cause someone to fall, trip and fall, if they were walking down the street. The likelihood of them tripping and falling and injuring themselves in a substantial way is not very likely. However, the cost of replacing the sidewalk would be very substantial compared to the cost of somebody actually being injured. So the reasonable person standard would basically suggest that a reasonable person might fix if there was any significant cracks, but if there's inconsequential cracks in the sidewalk, you wouldn't fix it. Because a reasonable person wouldn't expect that a person would trip and get so injured on that crack as to cause any significant injuries. Okay? If there's a big heave and one side of the sidewalk was up and one side was down, a reasonable person would expect that you would fix that. Okay? The third element, and possibly the most difficult one to prove, is proximate cause. Proximate cause is the legal connection between the negligent act and the resulting injury. Without the proximate cause, the injury would not have occurred. And what we use in this case is what we call the foreseeability test. Is it foreseeable that if somebody acted in a certain fashion or didn't act in a certain fashion, somebody could be injured as a result of that? It's the case of Mrs. Palsgraf. She was waiting on a train platform on Long Island. And has anybody been to Long Island? Okay. Has anybody ever been on a train platform down there? Okay. So you're up on this train platform, and the train usually pulls into the station, and oftentimes there are these big, almost like I guess almost like a light type of thing that kind of looks over the train platform and casts light. Back in the day, they were scales. They were scales that were attached to these kind of overhanging, poles, if you will. Okay. So she was waiting on the train platform. As another train was pulling into the station, a man carrying a package ran to catch that train. As he was running to catch that train, a railroad attendant on the platform helped push the man forward, and an attendant on the train helped pull him onto the train. Okay. In the process, the man's plainly wrapped package fell to the ground. That package actually contained fireworks. And as a result of them falling to the ground, the fireworks exploded. The explosion actually shook the train platform, causing one of these giant overhanging poles to fall and cause injury to Mrs. Palsgraf. It actually fell and hit her. So Mrs. Palsgraf decided to sue the Long Island Railroad. What do you think as to whether or not she won her case? How many think she won her case? Aiden thinks so. How many think she didn't win her case? Okay. Why? Why do you think she didn't win her case? Most of you said you didn't. Okay, go ahead. Reba?
There was no way for the person that was pushing them on the train or preventing to know if there was fireworks in there.
Correct. Right. So think about the chain of events that took place there. Now, Mrs. Palsgraf, she may have indeed had a case that could have been won against the man that was being pushed up onto the train platform because he was carrying fireworks. Now, it wouldn't be a negligence case. In actuality, it would probably be a strict liability case, okay? But she really lost her case against the Long Island Railroad because of the proximate cause test. Did the Long Island Railroad have a duty of care to patrons that are standing on their platform? Yes, absolutely. They have to make sure that the platform is safe for the people on the platform. Did they breach their duty of care against Mrs. Palsgraf? Maybe not. Okay, hard to say. Maybe if they pushed her as they were helping to push this guy up, you could say they breached their duty of care. And as it relates to the man getting up onto the train, they absolutely breached their duty of care because he could have gotten injured in so many ways. You know, you're pushing him up onto the train, he's being pulled up onto the train, any number of different things could have happened. Okay, so as to him, they definitely breached their duty of care to him. But as it relates to Mrs. Palsgraf, maybe not. There's probably a good argument you could make for yes, but a good argument for no. But this is the one they got hung up on because there's just no way that those train attendants knew that by helping that man get up onto the train that's moving away from the platform, the man would drop a package, and that package contains explosives, that the explosives would, damage the train platform, causing this giant scale to fall and hit her. Like, the chain of events is just not foreseeable. As it relates to him, definitely. If he had gotten injured, he could have definitely claimed negligence, okay? and won. Even though he was the one that was running for the train. Okay? The fact that they assisted and should not have would have resulted in their negligence. Okay? And then, go ahead. Did you have a question, Logan?
Wouldn't it kind of be like strict liability because he was doing something hazardous or whatever?
No, he was doing something hazardous to himself. He was not doing anything hazardous to her. Okay? So that's why it's not strict liability. But it could be strict liability as it relates to the explosives. So that's why I say she could potentially sue him for strict liability. Okay? So, and then our last element, actual harm. As it relates to Mrs. Palsgraf, there was actual harm, but she didn't win her case strictly because she couldn't pass the proximate cause test. In all likelihood, she did turn around and sue him as well. All right. So, what are our defenses to negligence? Did you have a question? Say what? No, there's no double jeopardy in tort law. Okay. So defenses to negligence. So we said that there were all those 4 elements. So the first defense to negligence is going to demonstrate that one of those elements is not present. Just like in the case with Mrs. Palsgraf. The defense, the Long Island Railroad, is going to basically say there was no proximate cause. As soon as one of those elements is not present, the case will fail. The second defense to negligence is contributory negligence. And depending upon the state that you live in, there's either going to be contributory negligence or comparative negligence. And with contributory negligence, this is where the behavior of the plaintiff helps cause his own injuries. And if you're in a state where there's contributory negligence, if the plaintiff helped to cause his or her injuries, they will receive nothing and they will lose the case. So, if we had a case, hold on. Okay, so in the case with Mrs. Palsgraf and the gentleman on the train platform. So if the gentleman on the train platform decided to sue the Long Island Railroad, in his instance, if we were in a state that was a contributory negligence state, he would lose because he contributed to his own injuries. So therefore, he would be done and he would lose the case. With comparative negligence, this is where the court analyzes what portion of the negligence each party contributed to the situation. And based on the determination, the plaintiff would recover some portion of the case, some portion of their, whatever they were requesting as to the damages based on their contribution to the injuries. So if they contributed 20% and they were suing for, say, $100,000, then the most that they could possibly get would be $80,000, because if they contributed 20%, the court would deduct the 20% that they contributed from the award. Does that make sense? Okay. However, there's a 50% rule. If the plaintiff contributed 50% or more to their own injuries, then they would not win. They might win the case, but they wouldn't be awarded any penalties. Okay? Because they were more than 50% responsible. Okay, and then the fourth defense is assumption of risk. If the defendant can show that the plaintiff knew the risk and assumed that risk anyway and got injured, then that would be the fourth defense. So that's your case where somebody, for instance, goes and does bungee jumping, okay, and they want to turn around and sue the person who is coordinating the bungee jumping. Then in that particular case, you assumed the risk, okay, and you got injured, okay. Now, however, if the bungee jumping cords were defective or something along those lines, you might still have valid grounds because you assumed a level of risk, assuming the gear that you're using is going to be effective. It's not going to be damaged, okay? And then lastly, we have the strict liability. So all of that we just went over is all just relating to negligence. So the second unintentional tort is strict liability. And as we said before, some activities are so dangerous that the law will apply neither the principles of negligence nor the rules of intentional torts to prove that the defendant was guilty. If these activities injure someone or damage their property, the people engaged in them are responsible regardless of how careful they were and regardless of their intent. Strict liability is intended to really protect individuals from injury of others, where the other party might, you don't have to apply the principles of negligence because you'd have to prove those 4 elements are present, okay? With strict liability, you don't have to prove those 4 elements are present because those activities are so dangerous that they could cause injury, even if you were very careful. A subset of strict liability is product liability. And this applies to any products. And you've heard about cases involving product liability. And this is where somebody gets injured because a product is defective. And in the case of a product liability, both the manufacturer and the seller of that product can be held liable. Fault, again, just like strict liability itself, does not matter. And it does not apply to casual sellers. What a casual seller is, like you or I, would be casual seller. We don't normally engage in the sale or distribution of that particular product. So an example of strict liability. A couple years ago, anybody remember hearing about some cases involving Toyota cars?
Yeah, airbag.
No, Toyota's wasn't the airbag.
The brake, or the gas.
Accelerator. Okay. Manufacturers of the products are considered to be held strictly liable for their products and any defects associated with them. The intent here is to basically ensure that manufacturers don't take risks with people's lives relating to their products and not do anything about it. Okay? So, in actuality, my understanding is that Toyota did actually know about the defective product. They just were gambling, basically, on whether or not people would get injured and sue them. Okay? They decided that, to fix it would be a very costly thing. And, because to fix something like that means you're actually stopping your manufacturing line, maybe having to retool the manufacturing line, redesign stuff, etc. And so it's very costly. And they, could be in the hundreds of millions of dollars to literally retool a manufacturing line, to be able to change a process in the manufacturing of a product. So they decided they would take a chance and see. And unfortunately, it resulted in injuries and death of several people. So then when the cases started coming up and the injured parties started to sue them, and then they found out there were multiple different cases, now not only do they have all these lawsuits out there for strict liability or product liability by the parties, individuals suing them, but now you have a government case against them, and then the government goes and, basically, penalizes them and charges them millions and millions of dollars. I don't remember what the settlements were for these cases, but they were very, very big. And now you have recalls. So it's it's very interesting to me that a company would do something as foolish as that, like that they wouldn't fix the product. But you see it time and time and time again as to why companies don't fix a product. They're taking a gamble. Okay. Tort reform, and that's some of what you guys have been doing with your Stella Awards, reading your Stella Award cases and doing a little research, has to do with tort reform. And so basically when we look at tort reform, it has to do with what we call survival statutes, which basically says a lawsuit can continue even if both the plaintiff and or the defendant die. Okay, so in tort reform, they're trying to maybe change some of that so that if the defendant dies, nobody can sue. But clearly, that would be, I don't know, I guess a little bit to me unethical, because a lot of times some of these injuries do result in somebody's death. So if they died, there would be no lawsuit, and that would be erroneous. And wrongful death statutes, again, a lawsuit can be brought by the relatives of a deceased to offset their loss, and this allows lawsuits even if the victim is dead. Okay, we're going to stop there.